It is not out of the realm of possibility that Judge Scott McAfee will say, okay, this trial, at least as pertains to you, Donald Trump, is going to have to be on hold.
Right. And also I will additionally mention that the presidential immunity motion, Trump also has this weird double jeopardy clause argument that is kind of.
Well, that's already been, he does, but the Supreme Court was like, no, we're not looking at that. Please don't come here and talk to us. Welcome to Law and Chaos. Today is an all-Trump show again. It's nightmarish and it's crazy, but at least we won't have to talk about the Fifth Circuit for a minute. Trump's New York trial starts a week from today. He's gagged some more in that case, and he is getting desperate. We will run it all down with Lawfare's Anna Bauer, a singular expert in this field. We've got a lot to cover, so let's get after it. Happy Monday, Chaos Monkeys. I am so very excited to talk to Anna in the main show. She's amazing. But first, as promised on Friday, let's get into the amazing shit show that is Trump's bond in the civil fraud case. When last we left our villain, the appellate division had permitted him to stave off collections by the New York Attorney General by posting $175 million instead of the north of $500 million, including interest and penalties, which would have been required had he been any normal defendant. I assumed that he would go with his longtime insurer, Chubb, which underwrote the $91 million bond in the E. Jean Carroll case. But I was wrong, because on Monday, he announced that a rando billionaire from California named Don Hankey had stepped forward to do him a solid. Hankey made his fortune in subprime car loans, and there was a lot of coverage of him like repossessing cars from service members and the like. He's a peach. Anyway, one of Hankey's companies called Knight Specialty Insurance underwrites the note. But of course, because it's Trump, this whole thing goes sideways. The first thing that happens is on Wednesday, the court kicks the bond documents because they're missing a financial disclosure and a signature and a power of attorney. Like, fine, okay, those are all kind of ministerial and that can be easily fixed. Although I would note that Chubb did not have any difficulty completing that assignment the first time on the E. Jean Carroll bond. So Knight resubmits its homework, and immediately New York practitioners are like, yeah, no, that's not going to fly. Because New York law doesn't let just anyone write a bond, particularly because, and to be clear, I myself did not understand this until this week, the bond company doesn't actually have to hand over the cash. It has to promise to hand the cash over to the state if the client loses his appeal. But it does have to promise that it has the money on hand, and it has to be licensed in the state of New York. And as to those three requirements, Knight appears to be 0 for 3. That is, it does not appear to be licensed in the state of New York. And the language of the document submitted to the court guaranteed that the defendants would pay the money if they lost their appeal, not Knight. And hello, how would that help the state? They don't want a promise from Trump. They want cash. But most importantly, Knight does not appear to be adequately capitalized. Like the back of the napkin financial statement they submitted appeared to show that they had $27 million in cash and a bunch of securities, which along with the cash add up to $138 million. And you will note that 138 is less than 175 plus the statutory cushion, which the state of New York requires of people who are writing surety bonds. Now, Trump's lawyers claim that these are all just details to be worked out along the way. And when A.G. James filed a motion to clarify just how on earth Knight is qualified to underwrite this bond, Trump's lawyers screamed bloody murder about that. But in the meantime, ProPublica, a nonprofit news organization, called up Hankey, who interrupted his game of bocce to flap his yap about having reached out to Trump before he got his bond reduced. And Hankey said he offered to underwrite the original $500 million plus note, which, as the article points out, would seem to undercut the representations Trump's lawyers were making to the appellate division about how it was going to be totally impossible for Trump to get a bond at that, $500 million level. The argument ProPublica is making, or what they're suggesting here, is that the lawyers had a duty to tell the court if their prior representations turned out to be wrong. And they'd said, it's impossible to get this bond. And then here was this weirdo being like, hey, let me give you $500 million. I would note, however, that the subsequent omni-shambles with Knight and the bond that it tried to write suggest that when those lawyers told the court that no one could underwrite the bond, they were not incorrect. Hanke, when he was chatting with ProPublica, also said that they, being the lawyers, thanked us for trying to help and said maybe next year we'll try to do business again, which does sound a little bribey when you look at it a certain kind of way. Perhaps, though, the lawyers were just talking about a criminal release bond in 2025, as in, like, maybe you can do business with us next year if we have to bond our dipshit client out of jail on appeal. Anyway, in the meantime, Hanke called ProPublica back and said maybe he misremembered before, but then he forgot to forget again because he got on the phone with Reuters and said how surprised he was that he'd gotten all this blowback from bonding out a stand-up guy like Trump, and he was thinking he maybe should have charged more money on the note. And also he said about that money, he's pretty sure that Trump is good for it, and it's sitting there in an account he can get to where, if he needs it. Although, as to the source of that money, he said, I don't know if it came from Donald Trump or Donald Trump and supporters, which would suggest that maybe Trump is using someone else's cash as collateral for this bond. I do not know, but I think it will probably come up at the hearing before Justice Arthur Engoron on April 22nd, which is in the middle of Trump's other trial in New York, but that trial will be on a break for Passover. All right, that is all very exciting. And what is also exciting is that you guys have been so supportive in reaching out to help this show become what I would like it to be. So as it's Monday, I'm going to thank a bunch of you. We're plowing through a bunch of names, and it's a good problem to have. So from Substack, let's thank Dr. Debbie, Bean, Nell, MJMB, Donna, Justin, Caesar, Mike, Stan, Steve, David, Sean, Salvador, Thaneo Fife, Geraldine, Isaiah, Benjamin, and Kate. And from Patreon, let's thank Colin, Shatsy, planning on Trump's win by learning other languages, Anarchic Rabbit, Narc, Gao, Matt, Mindy, Walt D, Besseman Matt, Isabella, Kitty, Jim, Sean, Diane, Kristen, David, IC, and my very good buddy, Fraud Fishy Hates Everything. If you would like to become a supporter of the show and get all of these episodes ad-free, please hit us up at lawandchaospod.com. That's on Substack, or at patreon.com/lawandchaospod. And if you're one of our supporters, on with the show. And if not, we will see you in a couple minutes after we pay some bills. And with us today is Lawfare's legal fellow and courts correspondent Anna Bauer. She covers all things Trump and is known for being the first reporter in line at the courthouse, whether that courthouse is in Florida or Georgia or New York or D.C. Anna, thank you so much for being here.
Thanks so much for having me, Liz.
So which courthouse are you at today?
So today I'm in Washington, D.C., but in keeping with my Carmen Sandiego lifestyle, I will be shipping off to New York very soon because we have a trial that is set to start in about, I think it's 8 days time now.
Yeah, a week from when this show drops. Monday the 15th, the same day as tax day, will be juror selection day.
Right. So I am headed to New York with some other members of the Lawfare team. We're going to be covering that trial in great detail. We're all going to be living together. It's going to be, a very interesting and fun 8 weeks covering that trial.
It'll be the nerd sleepover to end all nerd sleepovers.
Exactly.
And I mean that in the best way. I'm so jealous that I'm not there. So, all right. So you want to talk about the trial? I guess everybody kind of knows about the charges. That's the false business records case to cover up the Stormy Daniels hush money payment. We're all pretty familiar with the background. But do you want to talk about what's been going on in the past couple of weeks in that docket?
Yeah, sure. I think that there's a few things of note. One is that there's been some ongoing briefings and orders on a gag order that limits Trump's out-of-court statements and speech about the case. And the most notable thing in that regard is that Trump, after this original gag order was imposed by Justice Merchan, he started making these statements about the justice's daughter.
Right.
Some of them, making false statements about her Twitter or social media activity, implying that the judge was biased against him because of his daughter's job or political beliefs, that kind of thing. And as a result, the DA's office requested a clarification to whether the gag order applies to family members of the court. Judge Mershon responded by issuing an order that expanded that gag order to apply to relatives of the court or court staff. The order also added this, language to that in which it said, public statements about members of the court staff, if it was intended to intentionally interfere with the trial or the administration of justice. So there is that kind of little extra qualification. It's not just a kind of strict liability thing where if there's any statement about a member of Mershon's family, then Trump has violated the gag order. It has to be with this kind of certain level of intent or willfulness. So there's this expanded gag order. Trump then posted some links to articles in which...
By Laura Loomer. Articles by... Laura Loomer has been... let me just interrupt. I assume people don't exactly know who Laura Loomer is. If you know who she is, she's nuts. She's this... I think she's literally nuts, but she's this right-wing activist. She's the one who handcuffed herself to the headquarters of Twitter about 5 years ago to protest her account being canceled back when that was like a thing for right-wingers. She's a perennial candidate for Congress in West Palm Beach. She's not gonna unseat Representative Lois Lerner, but nice try, honey. And she also spreads a lot of crazy rumors. And indeed, she was the source during the New York civil fraud trial for these rumors about Justice Engoron's family. She said that this Twitter account, which posted anti-Trump content, was Justice Engoron's wife's account. That was not the case. And she said that a random bald dude sitting in the courtroom was Justice Engoron's son, and it was not. That was a New York Post reporter. So reposting her allegation that this Twitter account belongs to Justice Mershon's daughter is clearly not a credible source. And indeed, the court staff denied that it was her account.
Right. And so we had that happen. Trump just yesterday, I think it was, compared himself to Nelson Mandela and said
yes, I was just pulling that tweet up. I was just pulling that True Social up.
Why don't you read the tweet for us?
Yeah, Liz? Here we go. It says, page three. I do not know why he does not thread truths, or I call them burps, on his own bloody website. Seriously, why is it like this? But here's what he said. Now we have Mershon, who is not allowing me to talk, thereby violating the law and the Constitution all at once, is so bad at what he is trying to get away with. How is he even chosen for this case? I heard he fought like hell to get it, and all the rest of them also. Can I just pause in the middle? Is that how Justice Mershon got this case? He fought like hell to get it? Anna, is that a thing?
No, that's not a thing. He was
a judicial wheel thing. Of course. It's so crazy. Okay. I heard he fought like hell to get it, and all the rest of them also. If this partisan hack wants to put me in the clink for speaking the open and obvious truth, I will gladly become a modern-day Nelson Mandela. It will be my great honor, etc., etc. Trump is like Nelson Mandela, obviously.
Yeah, well, so Liz, what do you think the play is here? Why is he saying this? Does he want to become a kind of, is he trying to instigate Mershon throwing him in jail for a short amount of time? What's he trying to do?
Okay, first of all, I don't think that. Look, Rolling Stone reporter Aswin Subsang has suggested that his sources say that Trump likes to rattle the chains because he believes that no judge is going to put him in jail. And so far, he's been right. And I've been on record saying I don't think anybody's going to put him in jail pre-conviction. That would be crazy. He's got Secret Service. It's not going to happen. Certainly not for contempt of court. Although, I could be wrong. He's certainly pushing the limits here. Right, coming after the judge's daughter and, arguably violating that gag order immediately.
Yeah, I think that that's right. And I think that if Judge Mershon was going to do anything, if there is any sort of, motion to hold him in contempt or something like that, I think that we'd see something that we saw in the civil fraud case with, financial penalties or fines as opposed to throwing Trump in jail.
Right. And those fines were pretty de minimis, right? It was like a $5,000 fine and a $10,000 fine.
Right, exactly. But there's other things happening in the New York case this week as well. We had Justice Merchan issuing an order in which he denied Trump's pretty zany presidential immunity motion in limine.
And by zany, she means batshit.
And so if folks remember, this is the motion in limine, which a motion in limine is a motion to, exclude certain evidence or argument as you head into trial. Trump kind of tried to take the doctrine of presidential immunity, which is typically an immunity to not stand trial. It's not an evidentiary privilege, something that usually is used to say that you can't admit evidence or the prosecution can't use certain evidence in trial. But Trump tried to fashion the presidential immunity doctrine, even though it's questionable as to whether that even exists. And if it did, it wouldn't even apply here. But he tried to take presidential immunity and turn it into an evidentiary privilege, saying that the prosecution couldn't use any communications at trial that were tweets or posts or anything that Trump said during his presidency. They were basically trying to say you can't admit that or use it at trial. And then they also, in addition to saying that all of this evidence should be excluded, they also claimed that because the Supreme Court is going to take up the larger immunity question in relation to the DC federal election interference case, that Justice Merchan should adjourn the trial or delay it until the Supreme Court has decided on that. So they're basically using this as a way to, block evidence and then also get the trial to be delayed. Justice Merchan rejected those efforts, saying that Trump had filed this motion too late because they filed this motion at a time after all of these other pretrial motions had already been filed. The deadlines had passed. So Justice Merchan rejected the presidential immunity issue as untimely. So that, just put us right back on track for keeping this trial on April 15th.
Right. And look, you've been in the courtroom. I've spoken to others like Jose Pagliari that have said that Justice Merchan is already super pissed, and he's a pretty chill justice. Were you there a couple of weeks ago on the 25th of March for that hearing when Trump's lawyers tried to suggest that there was prosecutorial misconduct and discovery violations, and thus the case should be dismissed?
So I was not there, but my colleague at Lawfare, Tyler McBrien, was in the courtroom that day. And I believe when I spoke to him right afterward, his exact quote was, "Justice Merchan is pissed."
Yeah. Yeah. I mean, that was such a bogus motion, right? This suggestion that there had been discovery violations because the federal government, had been late in turning things over. And Trump's lawyers, Todd Blanche, said, well, this is, obviously this is imputed to the state. And like the state and the feds are not the same thing. The state and the Justice Department are not the same thing. So I think, just my point being that Justice Merchan goes into this mad, and he's not going to entertain any more dilatory motions, although there are more dilatory motions coming.
Yes, we've already had one more, which is a motion to recuse. Mm-hmm. And keep in mind, there are things that are coming onto this docket is at a very weird place in terms of what we know might be coming, and then what is public. There's a little bit of a delay because Justice Merchan got so angry with Trump for filing frivolous motions after various deadlines that he said, I want you to ask me for permission before you can file things now. Mm-hmm. So we're at this phase where there's all these letters that will be sent to Justice Merchan for asking for permission to file something. Then a few days will pass and he will either, allow them to file it or decline. So everything is coming on a very delayed schedule, but we did get a motion. This is Trump's second motion to recuse Justice Merchan. It is, again, based on these claims that his daughter, who works at a communications firm, has some kind of interest in the prosecution, or that the nature of her work, because you have a lot of clients who are Democratic campaigns, for example. The idea is that creates some sort of appearance of impropriety, having Justice Mershon presiding over the case while his daughter is someone who works for communications firms with a lot of Democratic clients. So there's this motion that is kind of renewed. They're making a lot of claims about the reason why they're making it again and why they're making it now, but it's basically just kind of regurgitating some of the political talking points that Trump has made about Justice Mershon's daughter. I don't expect it to succeed, but Liz, I'm curious for your thoughts on it.
You know, as someone who is more on the columnisty side and you're more on the journalisty side, you're being kind of generous. I think that this is like offensively bullshit. They make three kind of points. One is this extremely attenuated connection between Justice Mershon's daughter, whom I'm not naming, although she is named in the paperwork. But Justice Mershon's daughter, she works for a company which has clients who are like Kamala Harris and Adam Schiff and whatever. So she generates work for these clients. And some of these emails, which I believe the firm generates, mention Trump's legal travails. And thus she has, as they say, a stake. She has an economic stake in the outcome of the case and Trump's conviction. And thus Justice Mershon has an outcome. I mean, it's extraordinarily attenuated. It is not new. And he already kind of presented this issue to the Judicial Advisory Committee in New York. And the Judicial Advisory Committee said, no, it's fine. Don't worry about it. So that was like a year ago. So that's not new. The other things that they're complaining about are, I think Justice Mershon kind of gave an interview where he said, I'm not going to talk about this, but we're just trying to get, justice done, or words to that effect. And they said, well, that's an inappropriate commentary on the case. And like, no, it is not. That's, making that argument is it just refutes itself.
It was the most neutral. I mean, that statement that they point to where Justice Mershon did an interview with, I think it was the Associated Press. Mm-hmm. It's an incredibly neutral, bland statement that, I mean, judges can say statements like that.
Right. It's not prejudicial.
There was nothing prejudicial about it. Exactly. It is laughable that is the thing that they're trying to argue is somehow worthy of recusal.
Right. And Justice Mershon maybe publicly or is reported to have said once to his daughter, I don't think presidents should tweet. That's your prejudicial. Like, it's just crap.
Yeah, it's really, I don't think it's going anywhere. I think that, like, Liz, do you see anything? Because, with Trump's litigation, you honestly never know if there might be something that actually could delay or railroad the
He managed case. To do it once, right? This case should already be 3 weeks underway.
He should be at trial right now. I should be sitting in court right now. Exactly. I should be getting up at 3 a.m. to wait in line.
Be the first person on the list. You always are.
Exactly. But, everyone thought the case was going to trial. Then they sprung this discovery motion.
Right.
The case got delayed. We're 8 days out, 7 days when this podcast actually becomes public. Do you see anything that could happen that could put things off track?
I mean, I really don't think so, but I certainly think he's going to try. I certainly think he's going to kind of try and seek some kind of federal relief. He always does, and now that he's paying his lawyers through the PAC, he doesn't care. He'll give Todd Blanche all the money in the world, just like figure something out. I do think that they will try, but I don't think it's going to work. Justice Mershon's not going to do anything. I mean, and I guess he could roll the dice and see if he could get Judge Viscoso, who is on the New York federal court, and maybe she would issue some kind of emergency stay based on his immunity claims. But I don't think that's going to work. No, I think this is going to trial. I think you're going to be in New York. You're going to have your exciting sleepover party.
No, yeah, we're booking the Airbnb this week. I think it's going to happen.
Awesome. All right. Well, let's shift for a second. And I would like to talk about Georgia for a minute because you've spent so much time there. In fact, I think you're the person whose opinion I would trust most. What the hell is going on? Is this case ever going to go to trial?
Well, look, This case is probably going to go to trial, or at least some people are going to go to trial in this case. Remember, we started out with 19 co-defendants.
Yep.
It's now been whittled down because we've had 4 of the co-defendants who have pleaded to lesser charges. There is no trial date at the moment, although the district attorney's office has requested an August trial date. We are coming off the tail end of the disqualification issue related to Fulton County District Attorney Fani Willis's relationship with Special Prosecutor Nathan Wade, who has now resigned. So the big question now is whether or not the Court of Appeals takes up Trump and others' appeal of Judge McAfee's order denying the disqualification of Fani Willis. Remember, he basically gave her a choice of either recuse yourself or part ways with Special Prosecutor Nathan Wade. He then resigned later that day once the order was issued. Trump has appealed it, and there was this process in which you have to ask the trial judge for permission to appeal that, and so Trump's asked for that. It's called a certificate of immediate review, and Judge McAfee granted the certificate of immediate review, which then allowed Trump's team to submit an application for interlocutory appeal to the Georgia Court of Appeals. The Georgia Court of Appeals is now deciding whether or not to take up that appeal. And we just got this application for interlocutory appeal that was filed this past week. And after that application is filed, the Court of Appeals has 45 days to decide whether or not to take up the appeal. So we still don't know if there's going to be, this appeal that will be ongoing before the trial. What we also don't know, Liz, is whether the Court of Appeals will decide to stay or pause all the proceedings in the trial court. Judge McAfee, when he allowed these defendants to appeal that DQ order, he said, but I'm not going to stop the proceedings in the trial court. I'm still going to hear motions. I'm still going to rule on motions. And, he cited this case law that I looked at some of it. It has some pretty favorable language in there when it basically says that when there is an appeal, it's possible for the trial judge to continue to consider matters that, as long as they don't relate to that issue that's being appealed, and as long as there's not, an actual judgment that is entered. So you could basically do everything except go to trial and have a conviction and a sentence, basically. So all of this pretrial stuff, Judge McAfee wants to keep doing it, but the defendants are almost certainly want there to be a pause on those trial proceedings. And so there's very much this big question hanging in the air of whether or not the Court of Appeals will say, sorry, Judge McAfee, this appeal acts as a pause on all of the underlying litigation. And then also, Liz, there's this procedure within Georgia, appellate procedure, that if the Court of Appeals does take up this question, then those defendants can kind of, use that as a hook to bring in all these other appellate matters as well.
Oh, I hadn't heard that.
Yeah. And so there's a lot of things that could end up happening based on whether or not the Court of Appeals takes up the matter. I'm super curious to hear if you think that they will. I'm a little bit leaning on the side of they will decline to take the appeal. But I also think we will see a response from Fani Willis sometime soon, in which they will argue that the Court of Appeals should not take up the matter. So there's a number of different things going on here, but the kind of long story short is that in roughly 3 weeks, we should hear from the Court of Appeals as to whether they're going to take up the matter.
Yeah, I don't have an opinion on that one because I don't feel like I don't feel like I understand Georgia procedure enough, nor do I understand. And this is why we always talk to Andrew Fleischman. We talk to all these people on the ground. I don't understand the extent to which Georgia courts function as partisan organs, right? Like if you were talking about so many places like Texas or, where the courts are deeply political entities, they function in that way, like, look, Ken Paxton, Exhibit A, right? He's been able to avoid trial for so long and now appears to have wriggled out. So I don't know about that. I'm deeply interested to see, whether it's an issue of which panel he pulls or what it is.
Yeah, and there's definitely, so it'll be a 3-judge panel, but I think that there's an element to which, as in most courts,
Right.
it's always a question of who is on the panel. But I will say that Georgia courts, relative to, some courts that are more partisan, like in Texas, are pretty professionalized.
Mm-hmm.
We've already seen, for example, the Georgia Supreme Court that when Trump was trying to make all these weird arguments regarding, trying to put off his indictment based on these arguments about the evidence collected by the special purpose grand jury. The Georgia courts rejected that argument up to the Georgia Supreme Court, and we have a pretty professionalized legal establishment in Georgia. Also, keep in mind that when it comes to the Republican Party nationwide, and then you look at the Georgia Republican Party, there's at least half of it that is relatively sane to the other half of it. And I think that our courts also kind of reflect that a little bit more moderate impulse within the kind of, look, I don't want to say that these people are moderate, but
Right.
Relative to their counterparts within the MAGA movement, people like Kemp or Raffensperger are a little bit more, like I said, sane.
Right.
And so I think that our court system also reflects that kind of more moderate tendency within some Georgia Republicans as well. So I have confidence that the Georgia Court of Appeals will take the issue seriously and give it good consideration, but I just am not entirely sure what they're going to do. And talking to people on the ground here, I think everyone is very, it's a coin toss as to whether or not the Court of Appeals will take it up or will not. So we'll see. I know you've had Andrew Fleischman on, so did he have thoughts on this?
It was before this. It was before the certificate of immediate review had been issued. So I would like to have him back on to hear once it comes down, because he had quite a lot to say about Fani Willis's conduct. But okay, and I take your point about the Georgia judiciary being professionalized, right? Like Scott McAfee, I don't think anybody has a bad word to say about him, right? He's been pretty middle of the road. He's been and not incendiary, and not, he hasn't given Trump everything, but he's been so respectful. Even Trump was like, I'm not going to try and get federal removal. I like you, Judge McAfee.
Right. And Judge McAfee is a guy who was a member in the Federalist Society at the University of Georgia, where he was a law student. He worked in Trump's DOJ.
He also worked for DA Willis.
Yeah. And he also worked for DA Willis. And I think there's been some criticism of him for donating a very small, paltry sum to her campaign before he was a sitting judge. And people have called on him to recuse himself from the right based on that. But which is, to me, kind of an own goal, because Judge McAfee has, out of maybe any of the Judge Cannon, we'll get to that. But out of many of the judges who've been handling Trump cases, Judge McAfee is incredibly willing to let the defendants be heard. He has been really fair, I think.
And he was very hard on DA Willis. I mean, he called her behavior, he said there was an odor of mendacity about her behavior. I mean, look, if you were on the receiving end as a lawyer of the opinion that he rendered when he said, you're not disqualified, but your behavior is appalling, in more or less, he wasn't nice to her. But I want to circle back one time to Justice Merchan, because he donated a whopping $15 to the Biden campaign, and Trump's people have always, in very generalized terms, they always say, well, Your Honor's history of, donations to presidential campaigns draws his lack of bias into issue. And it's $15. So, I mean, whatever Judge McAfee donated to Fani Willis's similarly de minimis. It's not really a thing.
Right. And also, look, if Steve Sadow thought that it served the interest of his clients to seek Judge McAfee's recusal, he would have done it by now.
Right.
So, there's also the fact that under Georgia law, under Georgia Supreme Court precedent, a very small campaign donation, even if it had been done when Judge McAfee was a judge, would not be sufficient for his recusal.
Mm-hmm.
But, again, that with the federal removal proceedings, for example, part of the apparent calculation there is that you had Judge Steve Jones versus Judge McAfee. There was also some other things, I think, that went into the decision not to seek federal removal.
Agree.
But I think that a part of it had to do with the fact that Judge McAfee is a fair judge to these defendants. And I think that many of the defense counsel know that. I actually spoke to John Eastman at an event in January, and I was with another reporter from The Messenger, and we asked him, what do you think about Judge McAfee? And John Eastman was, saying, I think he's been a fair judge. I think that I haven't seen anything that he's done that hasn't been within the law. So when you have even defendants in the case saying that they feel that a judge has been fair to them, which is pretty unusual. I think many defendants often feel that they've gotten the short end of the stick from a judge. It usually means, that the judge has, really been willing to let the defense make their case. And so I think that it would be very surprising if any of the defense counsel in this case actually sought Judge McAfee's recusal.
Right. And it's a little late already. You're pretty deep into this trial.
Right. Exactly. But, as to the trial timing, I'm going to be really surprised if we see Trump going to trial in this case before the election. There's already this, pile up of different potential trial timing with the classified documents case, with the DC case. We've got the New York trial that's about to start, but also keep in mind that the presidential immunity motion that Trump has pending before Judge McAfee, which is very similar to the immunity motion that Trump's team made in federal court in the DC case. The DC case, presidential immunity motion, is being taken up by the United States Supreme Court. I think that probably the earliest that we will hear from the Supreme Court on that would be in June. As to the trial timing, keep in mind, Liz, we still have this pending presidential immunity motion in Fulton County that is before Judge McAfee, very similar to the presidential immunity motion that is going to the Supreme Court. Oral arguments starting later this month. I think the earliest that maybe the Supreme Court could decide on the presidential immunity issue would be June in relation to the DC case.
Thank you for saying that. I keep hearing these people who are like, well, it could happen in May. And I'm like, yeah, okay. I mean, sure. I think it's going to be one of the last cases they decide this term. I mean, I think that they'll come out with it in July just because of cussedness. I know we all know how there's going to go out. I mean, like the immunity motion is ridiculous. But I mean, well, is that what you think?
No, I'm with you. I think it's going to be July. And I think it's going to make it really hard for the DC case to go to trial before the election. But all of which is just to say that this presidential immunity motion that's very similar in Fulton County is one that, even if Judge McAfee goes ahead before the Supreme Court decides on the very similar issue, he's going to deny it. But then there's going to be a whole appellate process that they're going to go through in terms of appealing that decision by Judge McAfee. It eventually could get up to, the Supreme Court as well. So look, there's just a lot going on. And I think that I will be very surprised if Trump goes to trial in this case before the election. Doesn't mean, though, that there is a possibility that maybe Judge McAfee could sever some of these other defendants. Mm-hmm. He's discussed before that maybe he wants to do like 3 trial groups.
Let me just break in and just clear that up for maybe the non-lawyers listening. Trump has argued in D.C. in the election interference case that what he did, similar things, similar crimes to what he's alleged to have done in Georgia, similar in that Trump obstructed Congress, according to the D.C. election interference indictment, to prevent Biden's electoral certification. And in the Georgia RICO case, he's alleged to have impeded official processes to try and steal Georgia's 16 electoral votes from Joe Biden, right? And to prevent the appropriate certification. And they're different crimes, but they're related to the same thing. In D.C., he's argued that was part of his official duties because whatever, it's silly. And the D.C. Circuit said, no, that's dumb. And Trump appealed. And because that's on appeal, it has had the effect of staying the trial court. That's why Judge Tanya Chutkan had to stop and didn't get to go to trial in early March. There is a similar motion for immunity in front of Judge Scott McAfee where Trump is saying, I was doing official president stuff, and so I am immune for prosecution in this case. And it's pretty likely that Judge McAfee is going to deny that motion. But you run the risk that what's going to happen next is that Trump will take it to a federal judge, will appeal that ruling, and will say, I am entitled to stop this trial in the trial court. And, I'm not going to say that it's like an issue of settled law because who the hell has been here before? But it is not out of the realm of possibility that Judge Scott McAfee will say, okay, this trial, at least as pertains to you, Donald Trump, is going to have to be on hold.
Right. And also I will additionally mention that the presidential immunity motion, Trump also has this weird double jeopardy clause argument that is kind of...
Well, that's already been... Yeah, I mean, he does. But even the Supreme Court was like, no, we're not looking at that. Please don't come here and talk to us.
Right. But I mean, in Fulton County,
he
does the same. And one of the reasons why I think, I mean, if I had to take a wild guess, one of the reasons why I think that is in that motion is because double jeopardy arguments that are denied at the trial court level before trial are automatically appealable on interlocutory appeal in Georgia. And it would pause all the proceedings. It is possible that if Judge McAfee makes a factual finding that the double jeopardy clause argument is frivolous, which it is, when that is appealed before trial, then it wouldn't stay the proceedings. But all of which is just to say that, whatever Judge McAfee does on this, presidential immunity and double jeopardy argument that is, in the same kind of, in the same motion, it's going to be appealed. There's going to be additional litigation before we get to trial. Right. It may or may not cause the proceedings to be stayed. And so we have a ways to go in this case. It's at a posture that is much further behind than some of these other cases.
Okay. I think you might have mentioned that there could be severing, right? That he could go ahead with some of the other defendants, but we're nowhere near, are we?
Yes, right. So Judge McAfee could sever out some of these other defendants. He has mentioned this before, in fact, when there's been some discussion of trial dates. The state has said that they want to try everyone all together in one big trial. Judge McAfee, though, has expressed some concerns about the logistics of that. Where do you even have people sit? Like, there's no courtroom in Fulton County. There actually is one courtroom that might be big enough to hold everyone, but in fact, it's now being used for another multi-defendant case,
right,
RICO case,
right,
the YSL trial. And so, he's expressed some concerns about the logistics of all of this. He said at one point that maybe a way to do it would be to break the defendants up into 3 different trial groups. And so I think it's possible. There are people like John Eastman, for example, who has said, I want to go ahead and be tried before 2024 is over. There are other defendants who have these pending severance motions. So I do think that it's possible that maybe some of these defendants go to trial before the election, but it's almost certainly not going to include Trump.
Yeah, and I think some of these defendants are going to plead. Right. Right.
Oh,
I
for
think a
sure.
lot of them were waiting to see how this thing shakes out with the Georgia Court of Appeals, and I think that might concentrate the mind.
Right. I think that there was people waiting to see how things shake out with the disqualification motion, but also some of these other motions that relate to, that are dispositive.
Mm-hmm.
We've just had some rulings this week in terms of rejecting Trump and others, like a number of defendants who joined this argument, this First Amendment argument to throw
Mm-hmm.
out the RICO charge. There's still some pending motion. So I think that people are waiting to see how some of these things shake out. And it tends to be the closer you get to trial, as you know, Liz, the more pleas happen. We've seen these pleas come in waves.
Yeah.
And I think that maybe that's what we'll see again once some of these dispositive motions start, people really start to see exactly what it is that Judge McAfee is going to decide on some of these various issues.
Yeah, and let's move to Florida, but let's stay on this immunity issue for a second, because there is a pending motion to dismiss the Florida case based on presidential immunity because, I don't know. I mean, it's ridiculous, right? He said basically, like, I stole them when I was still president, and so I'm immune. I think that's functionally the entire argument. And we don't have to get into why that's dumb. I think it's self-explanatory, but we could see the same issue here, right? Because, as I recall, Jack Smith has asked Judge Eileen Cannon to certify that as a frivolous argument to stop Trump doing the same thing he did in D.C., and which is appealing it on grounds of presidential immunity and automatically staying the trial. But, I mean, I would not anticipate that Judge Cannon is going to be receptive to that.
I mean, look, I think that's right. I think that Judge Cannon, even when if you look at her orders, even when she denies something, she kind of takes pains to make sure that she is like really, putting it in the best light to Trump's arguments
Mm-hmm.
and really kind of, like I can't remember exactly what this order was even about, but there was this one denial that she did in which she spent the entire order talking about how great she thought Trump's argument was.
I remember that. Yes. Was that the one? It was like the one other. So Trump has filed 4 motions to dismiss on February 22nd. That they were just like each one more ridiculous than the last. And she, until this week, had only ruled on one of them. And I believe that was the motion to dismiss. Yes, it was vagueness of like Trump's argument is that the Espionage Act is just so vague. And how does he even know if it applies to him? And maybe he was keeping national security secrets. Who can even say? And thus the case should be dismissed for vagueness. And she denied that motion to dismiss. But she did it, as you said, in a way that was like, I really love this argument, and I really hope you bring it back up for the jury. And like, no, lady, that's a question of law. It's not a question for the jury.
Yeah, and so she does stuff like that where it's like there's clear appellate precedent that says this is not the way, and yet she still takes pains to like really put things in a good light for Trump. So I think that it's going to be really hard. She's not going to find that argument is frivolous.
No way. Yeah.
It's so we're going to, again, when we get to that point, there's going to be an appeal. We're going to go to the 11th Circuit, then maybe the Supreme Court, and it's probably it is going to stay the case.
Mm-hmm.
I mean, what we might have in the interim, though, is, in June or July, this decision from the Supreme Court in relation to the DC case, which might provide the special counsel with some, with some precedent to work with there in terms of maybe, trying to convince again, I don't know when she's going to rule on any of this stuff. So,
well, she's not going to rule immediately. I mean, look, there's been reporting from David Latt, who is a court watcher, and he reports that there's kind of turmoil in Judge Cannon's chambers, and she's losing law clerks, and that law clerks are withdrawing with the blessing of their future firm employers because having her name on their resume is not looking like the great bet that it was a year ago. And so, I mean, she's working very slowly, and the reporting is that she's like super stressed out by this entire case.
Yeah, I mean, when I went to the hearing there, it wasn't the latest hearing, but the one before that, in which we thought maybe she would set a trial date. She heard argument, which She still has not ruled on this issue,
Right.
but Trump has
She's
been
way
trying to
behind.
get, yeah, she's way behind. She's trying to get, they were trying to get an evidentiary hearing on the scope of the prosecution team, because they think that basically like every federal agency
Yeah.
in America somehow
The White House
is a part
Counsel's
of.
Office, the Department of Energy. These are all right. These are all discoverable entities according to Trump's counsel because, magic beans, whatever. It's a dumb argument.
Right. It's a dumb argument. Somehow she still hasn't ruled on it. It's totally, I mean, it makes no sense to me. This was weeks ago, and it's a quite simple, question to answer, is just whether or not to hold an evidentiary hearing. But at that hearing, it was, there was a back and forth, a pretty snappy back and forth, when Jay Brad at one point, kind of was saying to her, like, this is what we need to get moving on. And, Trump's team doesn't want to be doing anything during the New York trial, but we need to be doing this and that, blah, blah, blah. And she kind of, any time that there was any kind of, even a slight implication that she was not working at a fast pace, she would kind of snap back and say, I assure you that everyone in this chambers is, working, that there's much work going on in this chambers. And so she really, I think, did give off the impression to me that she was quite stressed about the number of motions that were piling up and that had not been, resolved. She mentioned several times to the special counsel's office this issue of these requests for redactions and how she felt like it was slowing down the litigation. But all of it just taken together gave me the impression that she was quite stressed by the, amount of papers in the case.
Yeah. And I think nobody likes to be criticized, but she's taken such broad opprobrium from the legal profession, right? If a firm says, we're going to not penalize you law clerk, for refusing to work for this federal judge, which is, a big honor, as you know, then I think that's a pretty tough hit for her. She knows that she's had so much criticism of what she did in the first time that this case was before her with respect to the search warrant. But okay, let's talk about what happened this week, which she's also taking quite a few hits on this week's decisions.
Yes. So this week, oh man, this week. So for background, Liz, there was this pending motion that Trump made regarding a motion to dismiss based on the Presidential Records Act. That is a statute that regulates, records that a president keeps while he is president. For the most part, presidents are required to hand over certain types of records. There's a kind of record keeping function to the statute, but also a government transparency kind of aim there, because, we want to have these records about what a president was doing in relation to their constitutional duties during their time as president.
Right. And to be clear, this statute, the predecessor to the statute, was enacted to stop Richard Nixon from taking the evidence from Watergate and destroying it. So Trump's claim here that the president can just magically transubstantiate any document in the government archive into a personal record and take it home with him, that can't be the case, because otherwise the law would be a total nullity. Nixon could have just said, I declare all this stuff personal. I'm taking my tapes with me when I leave. And the government couldn't do anything about it. It's a very silly argument. And like you said, now it's an obvious loser of an argument. And yet Judge Cannon seems unable to kind of make that. In fact, she appears to be entertaining this argument.
Yeah, she appears to be entertaining it. I mean, he initially made this on a motion to dismiss. She heard argument on it, seemed to be taking it seriously, but maybe had reservations about whether it was appropriate, to dismiss the charges at a motion to dismiss phase, as opposed to, maybe later on giving some kind of instruction to the jury about whether Trump had designated these records as personal or presidential.
Right. But let's be clear. He's not charged under the PRA. He's charged under the Espionage Act, and he's charged with obstruction of justice. The PRA is irrelevant to this case in the main.
Exactly. And there's an executive order that regulates, who can have access or possession of classified documents.
Does it say you can keep them in the bathroom? Does he say
Yeah, it
keep them
does
in the
not say
shower or in the ballroom
but
of a public club?
and so it's the point here, though, is that for the purpose of determining whether Trump had authorization to possess these classified documents, classification is not affected by whether the document is under the PRA, something that a president said this is personal, because a highly classified information can almost never, under the definitions in the Presidential Records Act, be personal, because the act, the definitions, if you look at it, it defines them of things as a purely private nature, things that don't relate to the president's constitutional or statutory duties, that kind of thing. Whereas highly classified information, that is clearly something that even if the act did apply, it would not be personal.
Right. And classification status is in some sense not even relevant, because the Espionage Act refers to national defense information. And so even if it was not classified, and a lot of it is classified, it would be national defense information. So Judge Cannon requested jury instructions, which took as their premise that Trump had the ability, before he left the White House or, whatever, to classify any document he liked as a personal record. And that's basically the first jury instruction said, let's write jury instructions saying that Trump could classify it as personal, and that it is the government's obligation to prove that he did not classify these documents as personal. That's a made-up thing. That's nowhere in law. And the second jury instruction was her saying that Trump has the absolute right to classify any document as personal and take it home with him. And the fact that he took it home with him makes it presumptively now a personal record. Well, that would just be like an instruction. That's basically saying, ladies and gentlemen of the jury, if Trump says that he had a right to keep this stuff, he had a right to keep this stuff, and you must acquit. And obviously, I don't think Jack Smith was happy about that.
No, he wasn't. And I mean, so this all follows this hearing on the motion to dismiss based on the Presidential Records Act. She, as you just explained, issued this very weird order. She hasn't even set a trial date. Usually jury instructions are dealt with closer to the trial date. Mm-hmm. There's something called a, jury charge conference that usually happens after a jury is seated and after, the evidence and defenses have been presented. But at this very weird stage of the case, she, enters this order saying, I want you all to brief this issue of the jury instructions on the Presidential Records Act and take what you just explained, Liz, those two scenarios. She has this language in the order where she says, and I want you to take these scenarios as correct statements of law, mm-hmm. which was very odd and bizarre to, order the parties to assume something that is absolutely wrong as a matter of law, right, to be a correct statement of law. So Jack Smith was not happy about this. They filed, response to this very weird, bizarre order in which they argued a number of different things, including the fact that they actually had a significant portion of the brief that made factual arguments that was very interesting, because they raised the fact to Judge Cannon that Trump, for several months when there was, exchanges between his attorneys and the National Archives over getting these documents back to the National Archives, once it became clear that there were missing presidential records, his own attorneys were calling these documents presidential records. They weren't.
He called them presidential records in his own communications in February. And more still, he could have moved to quash. He could have said, if he really at any point during this time believed that these were personal records, he could have moved to quash the subpoena on the grounds that they were personal records, which he had magically, with his mind, transmogrified into, his own personal property. He never said that. What he did was lie and say, I've given it all back to you. And then when the FBI showed up at his door, it turned out that was not the case. And it was only then that he said, well, actually, funny thing, actually, this is all my stuff. I made it all mine with the power of my mind, or maybe Reiki or something. I don't know. He laid his hands on it.
He only did that after Tom Fitton, who is not an attorney and is affiliated with the organization Judicial Watch, tweeted this bonkers theory of the Presidential Records Act. And so the special counsel raised all of this in this brief, also raised some of the arguments that we just went through in terms of why the PRA is not in the first place applicable to the question of whether something is, classified or, regulated by the order that affects, who can possess classified information, doesn't relate to national defense, whether something is national defense information, all of that. Mm-hmm. And so we had this, really tense briefing. It was a very, there was a little bit of sarcasm in there, I think, right. In terms, it was a very interesting filing. I have not seen a filing like that from the government yet. It seemed to be, they were really kind of reaching a new level of frustration with Judge Cannon, let's just say. But so then after we had this, briefing cycle, then a few days ago, Judge Cannon issues her order on the motion to dismiss based on the PRA. She denies Trump's motion.
Right. It was 2 pages. It took her 6 weeks. It's 2 pages, and only 1 page relates to the PRA. And she's really working very hard.
Is that she denies it, but doesn't really even say, she just says, this isn't the right time. It's not, she says on a motion to dismiss, I'm not going to dismiss these charges, but I'm dismissing it without prejudice, this argument.
So actually, let me cut in, because what she said was, it looked to me like agreeing with the special counsel. She said, well, the PRA is not involved with the charges here, so I'm not going to dismiss this because the PRA is irrelevant to the Espionage Act, which is what you're charged with. And I'm like, yeah, no shit, lady. That's why all of this rest of these PRA motions are dumb. That's why your jury instruction makes no sense. But so that was the first page of this whopping 2-page order that took her 6 weeks. And then the second page was her saying, no, I'm not going to rule now on this jury instructions thing. Why would you think just because I brought it up now that I should actually make a ruling now? Like, nobody was talking about this before Judge Cannon was like, hey, what about jury instructions right this minute?
It was bizarre because she was kind of like, how dare you ask me to rule on this jury instruction issue? As you know, special counsel, jury instruction rulings don't usually happen until after the evidence and defenses have been presented in the trial. But it's like, well, you brought it up. So.
Right. You brought it up and you suggested that you were going to do something so clearly erroneous that it would blow up the trial. And I just want to be clear here. The issue is once you get to the point where she's given the jury instructions, in fact, once the jury is sworn in, jeopardy attaches. And so there's not going to be a remedy here.
Right. And I think that is the thing that folks are so concerned about who are watching this case is that there's this possibility that if she issues an erroneous jury instruction that basically gives the jury license to, it amounts to basically like giving a directed verdict of acquittal because that jury instruction that she set out was just so generous to Trump that it basically would mean that he almost certainly would be, or would at least be likely to be acquitted. And if that happens, the government can't then appeal because once someone is acquitted, double jeopardy means that the government can't appeal and then have a retrial. So I think that is the big question. My colleague at Lawfare, Roger Parloff, was interested in this question about what could the government do once the jury is seated. And then if Judge Cannon indicates that she's going to give an erroneous jury instruction about the PRA, he found several cases in which the government, after the judge rules on a jury instruction, then sought an emergency writ of mandamus. That is a certain type of emergency relief that the government potentially could seek, but it's very hard to get mandamus relief. It has to be that there's basically no other options left. The error has to be really clear. And there's only a few examples in various appellate courts in which this has happened with a jury instruction. and he couldn't find any in the 11th Circuit, which is the appellate court that, governs here. So there's just this big question about whether or not, if after trial and after jeopardy attaches, if she does issue this erroneous jury instruction, will the special counsel have time to seek mandamus relief? But there is another option here that they could do before the jury is seated, which may be, a motion in limine, or which again is a type of motion that you file to exclude certain types of arguments or certain types of defenses that a defendant might raise at trial. They could do a motion in limine to exclude Trump from raising a defense based on the PRA. And then that way they would have, more time, more options for appealing any sort of adverse or erroneous order that Judge Cannon might issue.
Yeah, and props to Roger Parloff, your colleague, because he cited specific cases which the DOJ also cited. He anticipated it, or maybe gave them the idea. I don't know, but props to him. I personally find this alarming. So what's happened is Judge Cannon has refused to rule now, and okay, we are pretty far in advance, but that's a difficult thing to mandamus. Are you suggesting that the special counsel might seek mandamus now of her refusal to rule?
No, I actually don't know that there's anything to mandate unless you're seeking mandamus to get, there are examples where a judge maybe just hasn't ruled for many years. I think that one of my colleagues found an example where it was a judge had not ruled on something for 20 years or something ridiculous that. And so whoever the litigant was able to seek mandamus to get the judge to actually rule on the thing. But I'm just really I don't think that there's anything to seek a writ of mandamus for right now. Just merely saying I am going to rule on this later, rather than right now, as you've requested. I'm just not sure that is something that special counsel is going to try to, go to the 11th Circuit with. What I'm saying is that, there might be a motion in limine that they then, if they suspect that Judge Cannon would make some weird, PRA determination, the way to go ahead and get an idea of that and go ahead and take this to the 11th Circuit was be to specifically do a motion in limine to exclude Trump from raising the defense based on the PRA at trial. And then if she denies that, then you go to the 11th Circuit, and you're able to do that at that stage before the jury has been seated.
That's
so
interesting.
Does that make sense?
It absolutely does. That's so interesting, and I have not heard anybody say that. And I'm really glad that we got to talk, because I feel like so many people who are out there are saying well, now this is going to be, there's going to be the mandamus, and the 11th Circuit is going to toss Judge Cannon off the case. And that is hopium. I do not think that is at all likely anytime soon.
And I do think that's hopium at this point. There's the thing that Judge Cannon has done very well is she's done a lot of strange things in her orders and in some of her requests for briefing and stuff, but it hasn't been anything that has been outright enough yet for the special counsel to kind of expend that capital on going to seek a writ of mandamus. There's nothing that's been directly something that is just worthy of doing that yet, and it's going to happen. We're going to go to the 11th Circuit in this case. I feel quite confident in that, but it's just a question of on what issue, and at that point, whether it is on an interlocutory appeal or on a writ of mandamus or whatever. There are ways that in the 11th Circuit on appeal, you can seek reassignment of a case. I think that people have been very optimistic, or probably too optimistic, about the idea that the first time that special counsel goes to the 11th Circuit, it's going to be, reassigned to another judge. I think that that's pretty doubtful, maybe the second or third time. But I think the first time that they take it to the 11th Circuit, I'm a little bit doubtful that the 11th Circuit is going to reassign it to another judge. The cases that I've seen where there's been reassignment, it's usually something like the second or third time that the appellate court has told a judge to do something, and then maybe they find a way to get to the same result but in another erroneous kind of pathway, if that makes sense. And
right.
so,
or if like the judge is senile, which I think
the
happened
judge
pretty recently.
exactly. There's that too. And so I'm just really, I think that people need to have a pretty measured expectation about what the 11th Circuit is going to do, and when the special counsel is going to seek relief from the appellate courts. And I just don't think now is the time.
Yeah, I agree. I wish it were otherwise, but we live in this world. This is the real world. So, okay,
Mm-hmm.
Anna Bauer, thank you so much for being here. You guys should all follow her at Anna Bauer and at Lawfare, where she writes all the kinds of, and at Lawfare, where she will be covering all of these trials, and it is essential reading. Thank you so much for being here.
Thanks so much, Liz.
Law and Chaos Podcast is a production of Raise Up to Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Up to Media, LLC, all rights reserved.